Hi everyone, welcome to this session on private international law. Today we'll be looking at the choice of law rules that apply to tort and immovable property. Let's start with torts. A tort, as we all know, is a civil wrong that unfairly causes someone else to suffer loss or harm, resulting in legal liability for the person who commits the tortious act called a tortfeasor. The victim of the harm can recover the loss as damages in a lawsuit. Tortious claims are extremely common in international commercial disputes. In many cases, they appear alongside contractual claims. For example, a contractual misrepresentation claim is also likely to contain the cause of action for the tort of negligent misstatement. Parties may raise these claims in the alternative in the same case. Apart from negligence, defamation, nuisance, wrongful inducement of breach of contract, etc., all tend to feature in international disputes, either alongside contractual claims or on their own. Many conflict of laws situations can arise in torts. The wrongdoing may be committed in country A, but the action may be brought in country B. Sometimes the wrongdoing may be committed in country A, but the injury is experienced in country B. Each country's laws on the extent of liability may be different, and also damages awarded may be significantly higher or lower depending on the applicable law. Accordingly, the law applied to decide such disputes becomes extremely relevant. Historically, the choice was between either the lex fori, that is, the law of the forum, or the lex loci delicti, that is, the law of the place where the tort was committed. Different jurisdictions favored one of these two approaches. Note that neither of these two approaches were satisfactory in every case. The application of lex fori could sometimes be arbitrary and unjust. For example, when the wrongdoing took place abroad and the victim is also from abroad, but the forum is chosen only because the defendant resides there. Similarly, lex loci delicti can also be arbitrary. For example, where both parties are from country A and on vacation, one party ends up injuring the other in country B. Neither party is really related to country B in any manner to justify its application. That's why until recently, England and some other common law countries followed something called the double actionability test, meaning an action on tort could be successful only if the act was wrongful in both the place of wrongdoing as well as in the place of the forum. Eventually, however, because of the injustices the double actionability rule created, it was watered down, and ultimately in 1995 it was completely abolished by statute in England. Actionability is now primarily determined by the lex loci delicti. This gives rise to another complex question though, namely, where did the wrongdoing take place? This is not always easy to ascertain. The approach generally adopted was, when a tort is complete, to look back over the series of events constituting it and ask the question, where in substance did the cause of action arise? Let's look at a few cases in this regard. When a bill of lading alleged to contain a fraudulent misstatement was issued and delivered in the US, the tort was said to have been committed there, even though the bill was later assigned to a party in England. In a case where an English company had supplied a drug in Australia and the purchasers suffered an injury from the drug in Australia, the tort was said to have taken place in Australia as the failure to warn of the dangers of using the drug took place in Australia. When a firm was required to give advice and consultancy on the staining of stones, and certain negligent advice was subsequently given, the tort was said to have taken place in England where the advice was received, even though the testing and investigation forming the basis of the advice was done in Scotland. In India, while we do have decisions where the double actionability test has been applied following common law, we do not have any major decisions on this subject after the abolition of the rule in England. It thus remains to be seen what position the Indian courts will take in this regard. Let us now briefly look at the applicable law in relation to property disputes. The general rule is that all questions that arise in relation to immovable property are to be determined by applying the lex situs. This rule would cover questions of 1. Capacity to enter into a transfer of immovable property, 2. Nature and incidence of rights in immovable property, 3. The form in which the instrument transferring immovable property should be, etc. As discussed in Unit 2, this rule does not apply to pure contractual questions, even if the contract relates to immovable property. That concludes our discussion on the applicable laws for tort and property cases. We will continue to look at other applicable laws in the next video lecture. Thank you for watching.